When someone is charged with an indictable criminal offence, that's one of the more serious offences, an early step in the process is what's called committal. Committal is actually pretty simple. The prosecution has to persuade a magistrate that there is a prima facie case sufficient to convict the defendant. So they have to prove to the magistrate that they have enough evidence for the person to be convicted. The magistrate doesn't have to consider any possible defences, they just consider the strength of the prosecution argument. If the prosecution has enough evidence, the matter goes off for a full trial in the Supreme or District Court, usually in front of a jury. So the person is committed to trial. If the prosecution doesn't have enough evidence, then the person is discharged and they go free. In this case, Dr. Moss was charged with certain offences and committal took place. The magistrate decided that the prosecution did have enough evidence and so he was committed to trial. He then challenged that decision under the Administrative Decisions Judicial Review Act, arguing that committal was an administrative decision and that it had not been conducted properly. Now, at first blush, this seems like crazy talk. How can a magistrate sitting in court hearing the initial stages of a criminal matter be making an administrative decision and not a judicial decision? I mean, how much more judicial does it need to be? Well, the court found that committal is in fact an administrative process and not a judicial process, because it's part of the process of deciding whether or not a trial should happen at all. Once they are sent to trial, that's when the judicial decisions are made. Their Honours said the decision as to whether there is or is not a prima facie case, and if there is, the further decision as to whether or not to commit an accused person for trial are the central steps in the administrative process which is involved. To say that a magistrate hearing committal proceedings is bound to act judicially is to do no more than describe how he must perform his administrative function. It does not turn his decision into a judicial one, nor does it make his decision judicial in character. From this case, we learn just how difficult it can be to distinguish decisions of an administrative character from decisions of a judicial character.